First, I just want to apologize if my internet is a little shaky. It tends to be around this time, and I will try to keep my speech measured and sharing my screen and going back and forth between tabs and things like that. So apologies if you hear a sentence of mine kind of get clipped off at the end or if it's a little glitchy. Um, we all do our best in the Zoom age. Uh, My name is Jack Hornickle. I'm an attorney. I've been licensed to practice in New York for 8 years or so. And in that time, I've really only worked with farmers in nonprofit and pro bono capacity. I first was working through the Grow NYC green markets and providing legal services and business planning services to farmers that sell in the network of farmers markets in the city. So I come with a background in or exposure to farmers that are growing, diverse crops, uh, high intensity, a lot of hand labor and direct marketing, and that's a very specific type of agriculture, broadly in compared to agriculture generally, but um, it is it's the type of agriculture and food system that a lot of organizations are trying to support. So um, that's a limitation on my experience. So if you're calling in and you have a commodity dairy, a lease, we're talking about leasing tonight, a lease might look very different for your operation than for the leases that I'm used to writing up and helping clients use. So I just want to give that as a brief introduction. That's the type of farming that I've been supporting in my career. I now work at Pace Law School. We are located in White Plains, New York, and we run a clinic called the Food and Farm Business Law Clinic. In the law school world, clinics are a educational experience for students. So we have 8 to 10 students each semester who provide some transactional support, some business support to small farmers, and they do that. They help write contracts. They help with farmland leases. They help set up LLCs or other corporate entities. We answer some regulatory questions, some land use questions. We've helped businesses trademark a product. We've helped some craft beverage businesses, some related nonprofits. And all of this is to both to support the food system, our regional sustainable food system, but also to provide students with the opportunity to work directly with a client for the first time in their career. And so I'm speaking to you today as an attorney. I've worked with many farmers over my years, but also as a professor, as a supervisor of students, as an educator. We're at a very busy time of our academic season because the semester is concluding and the students are graduating imminently, and we're trying to get all of our projects done. So I was able to prepare some slides for today to talk about farmland leasing, and I'll do so in just a moment. I'll share my screen, and um, we can get into it. Uh, as a like a just a brief agenda for what we'll do today, I will tell you a little bit about uh, some like kind of legal background for farmland leasing, just some general thoughts on like what leases are, how they kind of fit within the law. I then like to go over some of the issues that were presented in the previous 2 sessions in this workshop series about issues that should be in leases, that leases should discuss. The landlord and the tenant should come to an agreement and put it in writing in the lease. I'd like to show you our lease template that we use in the law clinic. Whenever we have a client reach out asking for help with a lease, we start from this document, and we've updated it every year to include more of the issues that we've seen working with farmers. So it's highly relevant to farmland leasing, and like irrelevant to say renting a commercial storefront or renting a multi-unit apartment building. So we've refined this document to specifically serve small farmers and kind of predict the issues that would come up in a landlord tenant relationship on a farm. So I'll show you that document and we can look at it and what issues are in there and how they're addressed. And then lastly, I'd like to just present some scenarios to you that I've encountered many times in this work that are difficult to write, difficult to draft into a farmland lease, but they're common in our region in working with small farmers. So I'd like to just discuss some of those scenarios and hear from you about what uh, why you think that's hard to capture in a legally binding contract, and we can talk about that. And then, of course, we'll leave plenty of time for question and answer at the end, just open discussion about whatever you're working on, questions about how to engage with my services or other programs or anything else you want to talk about. And I see in the chat, yes, the slideshow will be available. I'll also send the lease template document for you all to see afterwards, and you can always follow up with questions, or if I refer to something, I'll be in touch. Okay, so I'm going to start sharing my screen now, and uh, first I just want to show you this is the website for our clinical program. Like I said, we're the law school at Pace University. You can find your way to the website. We're called the Food and Farm Business Law Clinic. And I think most importantly, there's a tab on the website that says information for prospective clients. And that will lead you to there's a hyperlink in here, an application, and that'll ask you some questions about who you are and what type of service you're looking for. But that's our starting point for working with farmers. I should note that we work with for-profit businesses and nonprofits, and they're both because we're a pro bono clinic. We're limited. We have income limitations for for-profit businesses. So if your household income exceeds a certain income limit, then in theory, you could afford legal services on your own. And the same is true with nonprofits. There are some large nonprofits who have the funds necessary to get legal services. So we have our own little test for whether they're eligible. But that's so that we can maintain our status as a educational and charitable program. But we don't ask to see your tax returns or anything. Just a self affirmation that you're modestly income enough to use our free services. So yeah, and the director of the program is Jonathan Brown. He's been running the program since 2017. I joined 3 years ago. We also have a professor of law, Margot Pollins, who lectures on food system issues and agriculture and the environment. And we have one staff person, Camden, who helps us administer the program and help us with our record keeping and things like that. So anyway, this is how our website looks, and if you want to request services, you can do that through here. So I'll start my slideshow now. This is our beautiful campus, and I'll be speaking about farmland leasing, of course. So just to start us off, leases, of course, they're a contract, and a contract we think of as a piece of paper, but contracts really are any agreement. Every time you go into a store, you see the price of a product, you hand the product and the cash to the clerk, you've engaged in some kind of contract. And there's this theory in the law called the statute of frauds, which there's some legal terminology that's genuinely ancient, and this is one of them. And it basically stands for the principle that certain contracts, unless they're in writing, are not enforceable. And that's true for leases. So any lease that is longer than 1 year regarding real estate, regarding land, real property, has to be in writing in order for it to be enforceable. So what does that mean for farmers? First of all, farmers, I believe, and this is part of our practice, farmers deserve modest or long-term leases. They deserve land security so that they can treat the land conscientiously, make good plans for their business. They're not facing eviction every year, getting kicked off, having to move. It's very expensive and stressful to move a farm business year over year. So we believe in the clinic that farmers deserve long-term leases. And that means that if they're staying on a property for any longer than 1 year, it has to be in writing in order for it to be enforceable. Um, if a lease is not in writing, you can think of it as an oral lease. It's a verbal lease. Sometimes they're called handshake leases because they're bound by the trust of one another by the hand, but they aren't enforceable in court. So if you have a handshake lease to farm out a property for 5 years and the landlord tells you to leave in year two, you really have no recourse. So we that's where a written lease comes into play. And so a written lease is not just a good exercise; it's actually kind of required by law if you want it to be enforceable. Uh, we often get a question about, well, what are my rights as a tenant? And the reality of landlord tenant law is that the law really favors the landlords. The law prioritizes the rights of those that own property over those that have access to it. And there actually are very few protections for tenants. A lot of the landlord tenant law that you hear about in the news is in reference to rent controlled or rent stabilized tenants in New York City, and for good reason. There are many of them. They have a sizable impact on the livelihood and the economic functioning of New York City. New York City is a large part of what this state is and does. And so every year, when you hear something about the New York State legislature trying to pass a law to protect tenants, it most often for rent stabilized, rent regulated tenants in New York City. And there's numerous programs that impact those people, but there's very little left for non-regulated tenants and the residents. So a farmland lease, you might think of it as something more than running a business because there's uh, so much that goes into it in terms of environmental considerations and social considerations. But in the end, the law will really just view it as a commercial lease, as if you were renting a warehouse or something. And there's very little in the way of the statutes that say what has to be in that lease or what cannot be in that lease. In fact, I would go so far as to say there's almost nothing in the law that says what has to be in a lease for farmland. For residential leases, there's a small amount, and for commercial leases, there's basically nothing. However, there are some protections in the process of being evicted, and that's the very last stop, right? We try to create good relationships between landlord and tenant by finding a good match, identifying the needs of both parties, negotiating a lease that meets both of those needs, drafting it so that it's clear, making sure that both parties have a copy of it and they understand, they revisit it regularly, they stay in good communication. There's a lot of preventative, proactive things to do to create a good landlord tenant relationship. But if it sours and they need to break the lease and move on, there are some basic protections here, some principles that I want to point out. The first is that landlords can use self-help in a commercial lease. Self-help is basically taking the law into your own hands. You can't use violence, of course, or property destruction. But in residential leases, a landlord needs to get a warrant from the sheriff in order to execute an eviction. And in commercial leases, landlords can use self-help, which it basically means you can lock the tenant out. You can lock the gate and throw their stuff out. That's self-help, doing it yourself. That is permissible only if it's stated in the lease. On the flip side, the tenant, if they're being evicted because they failed to meet some performance standard or some provision, not for lack of paying rent, but if they've violated some other provision of the lease, like let's say they were supposed to be using organic standards, but they needed to use some pesticide in an emergency situation, that uh, that bothers the landlord and they want to terminate the lease. The tenant can request this thing called a Yellowstone injunction in order to stay on the property while that proceeding plays out in court. The court will examine, well, were they allowed to use this or not? That's a genuine question of fact, and the tenant has the right to stay on the property until that question is resolved, which may be resolved in their favor. So it's not an immediate eviction. Uh, they can they're protected throughout that process. Tenants also can file a lawsuit in court to get the lock cut if they've been locked out. They can kind of get a reverse eviction in a sense. They have that right. And then lastly, if a landlord is unlawful or destroys property or is violent or is wrong about the eviction, the tenant can sue the landlord for what's called treble damages. And treble is just means triple. So, and this is very relevant for a farmer getting evicted unlawfully. You can imagine being kicked out of a farm property in the middle of the season and having a whole field go to waste, or even missing a couple of really important markets. That adds up really fast. And the tenant, if they're able to bring a claim in court and ask for triple the amount of their damages by being kicked out, that's a sizable claim against the landlord. That can be tens of thousands of dollars, depending on the situation. And that's both a legitimate claim in court, or that can be a bargaining tool in negotiating, finishing out the season on the property so that they can make accommodations somewhere else. So those are some of the things I wanted to share. Obviously, like I said, proactive relationship building, preventative steps. That's what we focus our time on. We do not litigate, but I just wanted to mention the sort of backstop law that applies in these situations for residential tenants and for commercial tenants. A few other things I want to mention. In New York State, when you buy property, you record the deed with the county clerk. That's the evidence of your ownership of real property. And you can actually record leases as well. For any lease that is over 3 years in length, remember it has to be in writing if it's over 1 year. And any lease that's in writing that's over 3 years can be recorded in the clerk's office, just like a deed would be. So a deed is evidence of ownership, and a lease would be evidence of occupation, possession, the rights to be on the property. And that can be useful. You can imagine a scenario where the owner is signing multiple leases. Say they sign a lease with a farmer, and then they sign a lease with a solar development, and the solar development comes in and starts to do what they think they have the right to do, which is put up fences and build new gravel roads and all this sort of stuff. And that could be in the middle of a pasture that a farmer had the right to. So by having the lease recorded at the county clerk, the farmer has a legal right, and it obviously they have a legal right to the property, but they have a clearer argument that the solar company had notice that there was a farmer already there. If it wasn't apparent from the equipment being around or there being animals in the pasture, they would point to, they go to court and they would point to the fact that the lease was on the public record and everyone should know, everyone has notice. So it has the same function as proving ownership like a deed does. And I just want to point out, you don't have to record the actual lease. You can record a memorandum, just the parties, the date it was signed, and just the big picture of the lease. And we recommend that, honestly, for leases that are 10 years in length, 20 years in length, because you might not ever revisit that document. It might feel like you have an ownership right, and the owners might, find themselves leasing out something that they weren't sure that they'd leased already. So anything over 10 years, we usually do put a provision in the lease that says the tenant is going to record this in the county records. And at the far end of the lease term, New York State, as those of you who own property know, when you buy property, there's a conveyance tax, like a sales tax, on buying real estate. And in New York, the timeline is that any lease that's 49 years or longer is considered a transfer of real estate, and it gets taxed. So I've also worked on projects where the farmer's like, well, we want a 100-year lease because we can't purchase the property. Sometimes it's just among family members or someone they know. We can't purchase it, but we want to stay here forever. Okay, that's fine. It's an agreement between you and the owner. You can strike whatever agreement you'd like. But if it's over 49 years in length, technically the amount of rent is like the conveyance and you get taxed. And I think generally people want to avoid that because they're they're not actually coming into ownership of the property. So that's just something to watch out for. We've had some projects kind of trip over that in the past. Okay, so thanks for indulging me on that. That was uh, just a couple of legal principles that I found relevant in my work on farmland leasing. Um, but like I said, the most important things to consider in leasing are the terms of the lease, the meeting of the minds, the contract that you as the landlord or tenant come with to the other party. Um, and those are can be very nuanced. They can be particular. Every farm is different. Every property is different, and a lot of farm businesses are different. So it really is important not to just take something you found on the internet or take a residential lease from an apartment you had when you were in college and write farm on the top. That really won't do it. You need to think very critically about how the property will be used over the term of the lease, and work with someone like myself or Haley and Melinda, extension agents or other support services, to make sure the lease is drafted in a way that makes sense and actually captures your agreement and captures all those little nuances that are different property to property. So these are some slides that were presented earlier in these sessions, but how do you determine rent? It's a perennial question. Basically, is whatever the two parties can agree to. You can look to other farms in the area for what their rental rates are. You can look at how much the farmer could earn by renting the property. Um, Obviously, the farmer can earn more money in certain crops than other crops, certain business types than other business types. I was going to suggest that they could earn more money growing cannabis than corn, but I actually don't know if that's the case, given the state of the cannabis market. Um, but you get the picture. And then, of course, the landowner has expenses. They have to cover taxes. They have to cover fixed costs. Someone needs to pay for utilities if they're involved. The land isn't free, even if it doesn't have a mortgage on it. There's always expenses for owning the land. There are surveys like uh, the horticultural team of Cornell Extension. I think Steve Hadcock has a survey every year that he puts out and reports on that has rental rates in the region. There's also a USDA survey, but I would say generally speaking, the survey responses are not enough to really rely on that any more so than just asking around in your neighborhood. And that it's so specific to an area and the qualities of the farm property that uh, it's better to just keep an open mind than try to think about it scientifically. The fact is there's no appraisals for leases for rental rates in the way that there's appraisals for buying a house. There aren't really comps. It's a different market, so there's not a reliable way to find the number. The number is really what you can agree to and what makes sense for both parties. What's being provided, if it's raw land or if there's buildings involved, or if the landlord is providing any heavy machine work or making improvements on behalf of the tenant or vice versa. So there's no right way to do it. And within the lease itself, there's a handful of topics that you really have to address in good detail. What is exactly being rented? Is it just land or does it include buildings? Does the tenant have the exclusive right to those buildings, or is it sort of a shared use? Is there equipment that's available? Is it always available, or is it not available on request? Uh, Describing the property specifically is really important. I always look up the tax parcel number because sometimes a street address either doesn't exist or it doesn't accurately describe where the field is that's being farmed. Street address is like a post office number. So maybe mail can be delivered there, but it doesn't describe the land that's being rented. So I try to hit it from every angle, and I usually add maps. I'll use um, Google or the soil survey website and make maps and draw on them using little software. And I think as specific as you can be is the best approach. The rights and obligations of each party, that's really the whole lease, is describing the different rights and responsibilities. And if there's any restrictions, that obviously should be really clear, in particular with types of businesses or types of production practices. So a farm rented out uh, for cannabis is different than a farm rented out for microgreens, is different than a farm rented out for uh, battery caged poultry production. Those are all very different uses of a property. And if you just describe it as for farming purposes, then the tenant can basically do whatever they think is reasonable within their business plan, and the landlord might want more restrictions than that. Improvements are really an important piece of this because this is another theory that I bring to my work, that the types of farms and the people interested in farming now that are the heirs to the agricultural history of the state, they're interested in something different than how the properties are built and capitalized. So, um, and the most common example is a dairy farm that has long since sold the herd, and they're renting a property to someone who is getting into organic vegetable production. The needs of the tenant in that situation are so different than what that property has been built to do over time. And that all comes down to what the improvements are. Where are the utilities accessed? What can the structures do for the property? How do they fit within this business plan? Where will the organic vegetable tenant wash and pack vegetables that is food safe? you know so all of these things, and generally speaking, the someone will need to make new investments or modifications to the improvements on the property. And so that raises all the questions of who's going to pay for it. Is it possible to own those separately? Can they be mobile or temporary? And who's responsible for any damages or maintenance? That whole set of questions is really important to nail down in a way that just defining which field is rented is kind of, it's almost an afterthought at that point, because you're talking about really specific financial um, financial decisions. And I think I sort of already addressed agricultural practices, but it's very important to name any restrictions on the property that the landlord desires, and make them clear. And another thing I would say about that is that it's useful to, if someone needs to monitor the uses on the property, to make that a third party as opposed to either the landlord or the tenant. So if you want to write in some standard that the tenant will farm conscientiously, taking care of the riparian corridor, or to avoid soil erosion or something like that, to refer to a third party like the extension office or the soil and water office to come make an evaluation if the landlord thinks that the tenant is doing a bad job meeting that obligation, so that it isn't just a subjective opinion of one party over the other, to pull out a technical and expert opinion to resolve a dispute if there is one. Um, Payment, I'll just skip to payment terms here. It is important to identify when payment will be made, just as much as it is to identify what payment will be made, whether it's money or share of crops. The when is really important to the tenant, in the sense that they might not have cash available at all times of the year. The spring, they're laying out cash to get the season started. The summer, it's possible that they have cash coming in, but it's probably going out to labor right away. The late fall, the real harvest season, that might be the most flush cash time. And definitely in November, December, that's the time where there's the most cash, and the strategy of how to pay it down what to report on for taxes, what to invest in. So I think there's a good time to pay rent and an inconvenient time to pay rent. That said, the landlord has a different timeline. Their taxes are due in January, usually also due in August or September. They might have, I mean, who knows when the insurance payment is due? They have a monthly mortgage payment. That's a whole nother thing. So it's important for the parties to identify the timing of the rent payment so that neither of them is in a cash squeeze, or neither of them is, demanding, the landlord's not demanding rent from the tenant when they don't have it, or when it would create unnecessary stress in an otherwise, successful, viable business that can pay the rent. They just can't pay it this week. So it's important to kind of think ahead about when the money will actually be moving. And you can mitigate that with a security deposit, or show your bank statement or something like that. We have written some leases about with that predict crop sharing, and to be honest, in the small farm direct market vegetable world, like I said, that's what I have my most experience in. It's sort of hard to write that in a way that's meaningful. We've mostly written that in as that the tenant will provide a weekly CSA. If they run a CSA, then they'll give one share to the landlord. That's the easiest way to do it, but to have the tenant, report their farmers market sales for that week and do a division of 10% and then pay that. Is it sales or is it profit? And if it's profit, how do you account for the labor, even the marketing labor? We found that very challenging, and I think that landlords and tenants, because they want to be creative, they'll suggest that, and I've yet to find a good way to really uh, frame that in a way that kind of makes financial sense. Um, and I understand that the parties are trying to avoid exchanging cash. They're trying to share in the bounty, and I want to support that. But I found it pretty hard to uh, create a meaningful exchange. Of course, in the commodity world, that's a very different circumstance. Yeah, at this last point here, bringing land back into production is back to what I was saying about improvements. The tenant is not necessarily taking over the property as an operational farm in the exact way that they want to operate the farm. So even improvements to the land itself, making soil amendments or planting cover crops and turning them under and improving the soil, all these things take time and take investment in cash, investment in labor, and those should be accounted for. Um, just having land available for a farmer to farm is not always that valuable, if that makes sense. The farmer tenant often needs to do a lot of work in order to make it viable for their own needs. And I think some of the previous presentations have shown you tools that can be used to research the property and identify the qualities of the property before you're making a long-term commitment to it, so that you know it basically has what you need, and you can kind of picture how you'll bring it into a productive, viable operation over time. What I'll say about length of agreement, you've heard me talk about 1 year needs to be in writing, 3 years, you can record it with the deed. 5 years is a way to get the agricultural assessment to apply. It's not required for that program, but it's sort of the standard, and a lot of assessors look to a 5 year lease as proof that the property will remain in farming. So 5 years is sort of our starting point. That's what we like to begin with in a negotiation, because again, it provides the amount of security that a farmer needs to start a business and take the risk of starting a business. One way that we can approach that is by using renewal terms. And so you can think of a 5 year lease as the same as a 1 year lease that can be renewed 4 extra times. And in effect, they're the same thing, but they provide an opportunity for the parties to revisit certain issues. You could also have a renewal that's triggered or it's conditioned on a certain event happening, or a certain sales figure being hit, or a certain production practice, or new enterprise. You can be very creative in uh, how you prescribe the length of the lease. with and link it to other concepts that are important to the two parties. So I was working with a tenant today who's looking at starting with 2 years, but then with the right to renew as long as the business is consistent with the landowners, business plan, their strategic plan that they're putting together. And so you can kind of create these like, slight rooms for renegotiation at certain times, but generally speaking, you still have a long term. And that's a way of kind of mitigating, maybe the landlord isn't ready to fully commit for a long time. The tenant needs that commitment. The landlord might want to renegotiate rent, but not to exceed a 5% increase. Things like that. You can kind of create small rooms for renegotiation without making it a full negotiation every 2 years or whatever. That saves everyone time and anxiety. It also saves all of us time, all of us service providers time, because we don't have to start over from square one every 2 years. We can kind of build a document that lasts and gets renewed. Early termination, I was working on something today where the parties wanted to be able to terminate early so they both could get out of the agreement, and that's fine. The way that I ended up writing it was that either of them could notify the other they wanted to end the agreement, but they had to wait till the end of the year. It would only be effective the next season. And that's really to preserve both of them, that the farm isn't just abandoned in the middle of the season, and that the farmer can't get kicked off in the middle of the season. And I guess you can hear in a couple of my comments here that I think that I think these relationships should be long and durable. And most of all, I think that the farmers should just be able to focus on producing food during the season. Uh, and so a lot of the things that I've written into leases are aimed at providing that security during the season. We can pay the rent. We can talk about the terms between December and February. Um, but while the food is growing, I'm going to be attending to the food. So that's a little bit of my bias. Uh, Taxes are always paid by the owner. The owner is named on the bill. The rent can either be reimbursed or cover those taxes. I haven't really seen tenants pay taxes directly, and I think the previous sessions have talked about the agricultural assessment. Sorry, I skipped over insurance. I think it is important for both parties to have their own insurance and to like cross insure each other where it's appropriate. So, for example, the landlord might have a home ownership policy that covers the buildings. We want to make sure that policy has replacement limits that are sufficient to actually rebuild the buildings, because to the landlord, whether they would actually replace a barn, that's their decision. But to the tenant who's renting that barn, it's very important that there's sufficient funds to rebuild it and on a reasonable timeline. Otherwise, otherwise the landlord might be defaulting on the lease, and the tenant's business is substantially interrupted. So from the landlord side, the insurance should it should they should probably have a little bit of over coverage in order to make sure that the tenant has what they need. And for the tenant who has like a general liability insurance for their operations, they should always be naming the landlord as an insured party, because if there was ever a person who was injured on the property or a person who was made sick by the product that the tenant was growing, we want to make sure that the landlord is not named as a party in that lawsuit, that the property itself is not subject to a claim, a legal claim that is generated or comes through the farmer's operation. So that's an issue of insurance, and also in the law what's called indemnification, where the parties agree to basically cover each other's risk. Um, and then, yeah, provisions for arbitration and disagreement. I want to point out there's a program in New York State called the Agricultural Mediation Program, and they are basically a hotline. You can ask for mediation services on issues related to farm tenancy, and they will find someone in your area who will help mediate a dispute. And generally, it's free. You may have to pay to rent the Elks Lodge or whatever neutral space to go for the meeting, but the mediator itself is a volunteer, and the coordinators are paid through New York State and other grants. So this is a free resource available to farmers. They They do wonderful work. They're very understanding about how complex landlord-tenant relationships can be, and they're also very proactive. That mediation doesn't have to be used just for a knockout brawl sort of dispute, but to help get through a problem issue so that the relationship can continue. And I guess I would also say about mediation that mediation is a non-binding, it's a facilitated conversation. Arbitration is sort of a substitute for going to court. It is binding, and then going to court is like what I discussed at the beginning. You'd be filing a lawsuit, like, and you'd go to the town court on a lease, and you would have a, you could represent yourself. You might hire a lawyer, but that you'd be, seeking eviction and seeking money damages. So it's a different formalized process than mediation, which is genuinely trying to seek a resolution to the issue. And I didn't see this in the original slides, but I do want to point out that utilities are really important. Back to what I said about the layout of the farm and the capitalization of a farm. I've seen this a lot, that there's a single well that serves the house, the barn, and the greenhouse. And that well is going to run dry in a drought. And the landlord is going to take a shower while the farmer is watering their microgreens. And then people will get upset. So this is a challenge. Who will bear the cost of drilling a new well? Is it necessary? Where is the water table? How much will that cost? The same can be said about electricity. 1 meter that services the house, the barn, and is run out into the field. And you know, there's no shortage of those of issues that come up when a business is using the same utilities as a resident on that property. And so it's just important to distinguish who's responsible for the payment and how are they reimbursing each other for the amount that they use, and what will happen when inevitably there's not enough for everyone to go around. And that's unique to farming, but it's so common that the farmsteads have all the utilities in one place and everyone's trying to rely on them for various things. Okay, so with all that in mind, all these different issues, you can start to understand how they lock in with each other. How does the length of the lease relate to the cost of the lease? How do the improvements that are there or that need to be built relate to the cost? Um, all these things relate to each other, and so building a lease, negotiating a lease, and then drafting it is really it's a really fun exercise. It's you might think of negotiations as sort of heated zero sum games, but actually they're very collaborative because I think both parties come together. They want to see the farm succeed, they want to see the property in farming, and we as the lawyers get to help problem solve and come up with new ideas about how to make these issues fit together just so that everyone gets what they need. You can't always get what you want, but sometimes if you try, you get what you need. And that we find ourselves in that position quite a bit, that people are able to move forward because we've thought through how all these things relate to each other and found some happy medium that gets everyone just enough to, agree to something that's really, really valuable, which is land security for a farmer who's, growing food and selling it to the public. So I'm going to share now the lease template that we've designed in the clinic. And so this is in the Word document, like you can see here. This we last revised it just a few months ago based on some new strategies that we thought of. And it does come this title page basically says this is a template. You can use it yourself. Some items are bold and bracketed because they're optional. But generally speaking, I want to advise you that this document isn't ready to sign. It's all the pieces that you might think about and rearrange and rephrase before signing. And our clinic is available to help you navigate this document. Haley, Melinda are available to help you navigate this document. Other programs like Extension, like my program, are able to help you navigate this document. If you just took it and signed it, and then you were in a dispute and the lawyer looked at it, it wouldn't make any sense. It's actually It's like I said, it's many pieces of the puzzle, but they're all kind of scattered throughout. So that's my warning that this isn't meant to be just signed. This is it's an instructional document that can be catered and customized with the help of others. So I'm not going to read these terms to you. They're basically all the things we just discussed, but I just want you to get a sense of how a lease looks, how it's laid out. So you have the parties named at the top. Whenever you see this word whereas in all caps, this is language that's not binding on the parties, but it helps tell a story. So we've included some language that, the landlord owns this land and they want to support small farmers, and the tenant is a small farm hoping to contribute to the local food system. And you can take this and run with it. You can tell a story here. It doesn't obligate either party to do anything. It's just a way of introducing to the reader why these parties are coming together in this contract. And then now, therefore, begins all of the issues that are the binding commitments, the rights and responsibilities of the parties. So here's the lease description, or the description of the property, the term, the rent, the use. So we have agricultural uses, and then we have some blank spaces for including but not limited to, and then all the specific things that we think the party might do. So those big ticket items are right at the beginning. Where's the property? How long is this lease? How much does it cost? And what are we allowed to do there? We have a pretty nuanced section here on conservation practices and certifications because, and we've also arranged them so that the kind of highest standards are on the top, and then they get a little more lax as they go down. Uh, you could apply all of these, but like for example, tenant shall follow sound agricultural practices. That's a very loose standard. That's the bare minimum basically for not being sued for creating nuisances. Um, but we further say including anything recommended by county soil and water. So if you have an agent that comes out and they make a recommendation, you want to document that. That's a useful thing to ask the tenant to stick to because some expert has come out and made some recommendation about what's good for the property. So these are all interchangeable, but they're there to help you think about what restrictions, what practices you might want to have on the property. We recommend regular, honest, forthright communication. You can set a timeline for that. This maintenance and repairs section is really anticipates buildings being rented, and so that's why it's so specific about the landlord will maintain the major structural components, the tenant will maintain the smaller things, um, the consumables basically. We have an extended section here on capital improvements, so that's new buildings, new things that could be built, and basically it says the tenant can't build anything without the landlord's permission. They'll submit a written proposal, written request to build something if they would like to. Anything that's temporary, they can take with them at the end of the lease. And anything that's permanent, they can either ask for that to be bought back from them when they leave, or uh, they can make an agreement that the landlord is going to pay some of it up front. It gives the parties flexibility on how to make those mutual investments, which can be, they'll come up in a 5-year lease. There's usually something will be, there'll be some investment in the property that someone has to take care of. Landlord always has right of entry into their own property. It's just set some expectations around it. Utilities, sort of as I discussed, taxes I discussed. There's 2 clauses here. One says tenant will assist the landlord in meeting the agricultural assessment, and one says tenant will guarantees that the property will meet the agricultural tax assessment. And so those are different obligations, but we recognize that sometimes the landlord is only interested in the tenant being there if they can be certain that they'll get this reduction in their taxes. So that can be an enforceable clause in the contract. Where if the tenant, fails to meet the sales minimum for the ag assessment program, they're in default on the lease. The lease can be terminated. They can be asked to leave. Insurance is required, as I mentioned. Indemnification, like I said, that's like the 2 parties kind of sharing the risk with each other. They'll both defend each other. There's another party suing them. This is an important one. We specify that this contract doesn't create a business partnership, even if it looks like that there's some collaboration. Even if the rent is being paid in vegetables, that doesn't mean that this is a business partnership, and that's important to keep the two parties separate so that they don't share risks and share liability. Um, it's generally true, but we have it stated here that this agreement is binding on any successors. So if the landlord sells the property, the new property owner has to abide by the lease for the remainder of the term. They don't necessarily have to renew it. They don't have to like the tenant, but they have to uphold the lease that was put in place by the former owner. Generally speaking, when parties default on a lease, we give them some time to fix the problem so that it isn't an instant eviction and an instant termination. And this gives tenant, the good faith effort to fix the problem. It's just names and addresses. Right of first refusal is a clause that would give the tenant the right to buy that property if the landlord was selling it. So the is on open market and or they receive an offer that they are considering, then it triggers the tenant's right to match that offer. And so in some circumstances, this doesn't make any sense because the tenant could never come up with the money or the financing. But in other circumstances, it can be really, really valuable that the tenant has the right to kind of intercept the sale. And the landlord gets what they wanted anyway. If they're trying to sell at a certain price, and they sell it to the tenant instead of some other party, the landlord is not inconvenienced by this, but the tenant has the right to stay on the property and then enjoy the benefits of ownership. Our dispute resolution clause specifically names the ag mediation program, so we do recommend that. And then the rest of this stuff is sort of what you call boilerplate. Uh, it says it's governed by New York law. If any of the provisions are illegal, then the rest of the lease stands. If the parties want to amend it, they have to do it in writing. If the parties are LLCs, then this sentence here has them affirming that the LLC is properly organized and that they're the actual owner of the LLC. It's a funny thing in New York. You can look up any LLC, but you can't look up who owns it. And the legislature has tried in many years, many different ways to find a way to make LLC ownership public information, and it isn't. So it can be challenging to identify who actually owns land, which is very inconvenient when you're trying to enter into a contract to use land. So we have this clause here that says the person signing this contract agrees that they are the owner. They have the authority to sign this. You can imagine the scenario if they didn't. And the parties can sign electronically or in different things. Here's what I was mentioning before about recording the lease. If you want to record it in the county records, you can. And that's it. And then there's the signature pages. And like I said, we like to attach a map if possible. Okay, I've talked quite a bit. I talked probably faster than I hoped to. I think my internet held through the whole time. And what I'd like to leave you with is, back in this presentation here, some of the challenging circumstances that they're not, I don't want to say that they're bad circumstances. I think they're good. I think they're informed by good intentions, but they're challenging to write. They're challenging to draft clear and durable contracts for. So maybe this is my problem and not your problem, but I just want to alert you to them. These are common circumstances that come up in small farming in the Hudson Valley that it can be kind of tricky to write a contract. So the first is the landlord is absent. They don't live on the property. They're a second homeowner or they're an investor group or something. And they have a high expectation for what that property looks like, the aesthetics of the property. So they rent it to a farmer who labors for a living. They struggle to establish a business. They're doing the best they can. Maybe the last thing on their mind is keeping the place tidy. The property owner comes up for the weekend and they see nursery trays all over the place, or there's like a huge pile of mulch in the driveway, the sort of things that just happen if you're in the middle of the season. And they expected something more like the background picture on this slideshow here, something tidy and beautiful. And of course, we want farms to look like this. We all love that picture of a farm, but that's just not the reality of running a small business sometimes. So these are very risky situations, in my opinion, because the landlord has a vision, the tenant has a need, and there's really no, it's very difficult to write a contract that says the tenant will always satisfy the landlord's subjective idea of beauty. That's just so hard. It's hard for them to do, and it's hard to describe it or create some performance measure. So that, we try to make sure that the parties communicate, and it's just a challenging situation. Another one is where the landlord is present. They live on the property, and they're farming also. Um, but because the tenant doesn't necessarily want to lay out the cash, they agree to help the landlord with their farm business. And now you get into this thing that looks a lot like a partnership. You have two parties that are working side by side. They're sharing equipment, they're sharing inputs. They might even share harvest and market channels and stuff. And now they're basically running a business together. And the lease, which is supposed to draw a line between who owns the property and who uses the property, uh, now it's just kind of, I mean, uh, it's not really effective anymore because they are just relying on each other to do everything. And there isn't anything wrong with that, but it's a different form of legal relationship, and the lease doesn't really stand anymore. It doesn't capture what they're doing, and they're really taking on each other's risk in a way that the lease is usually trying to draw a fine line between them. Uh, the third one here is that the landlord is an idealist. They want to create a farm collective or a farm community, and they have bring on multiple tenants onto the property. They want to see a vegetable farmer, they want to see a small livestock farmer, they want to see a flower farmer, and they bring them all on. But those farmers don't know each other. They just met, and now they all have leases on this property, and each of them has the motivation to be a successful business owner. And at best, the leases clarify whose areas are whose, but uh, usually it's very hard to organize those different parties on the same property without them conflicting at some point, over the shared utilities or something like that. And my question for you is, what is the recourse for each of those tenants if one of the other tenants has is inconvenienced or has a conflict? The landlord is the recourse. They all go up to the same party. So there's nothing lateral that unites these people. It's all vertical to the landlord, and the landlord becomes a uh, mediator in their own right, or something like that. And I've seen this scenario play out many times, and there's ways you can write the lease to say that the tenants have to meet with each other. But in the end, you're almost building like you're building a new company or something with all these different shareholders or something. So that one is very hard to capture in a lease and hard to make hard to enforce. And then lastly, this one is very straightforward. The tenant is just also renting a residence on the property, and you can think of why that would be a problem, or where problems would come up in that project. Because if there's a problem on the business side, it's going to become a problem on the resident side, or vice versa. And residential tenants have certain rights, commercial tenants have other rights. We've usually recommended that they have two distinct leases, and we try to tie them together in conscientious ways. But you want your rights and responsibilities to each of those areas very clear, so that the landlord who has a problem with some farm production practice can't kick you out of your house. There's an apartment above the barn or wherever the tenant is residing. You want to make sure that there's due process for each type of tenancy that there is on the property. And for just as much as farmland affordability is an issue in our region, the housing shortage is also an issue in our region. So we don't want someone who's struggling to run a business to get kicked out of where they live, because they could just as easily have another job and pay the rent and be a residential tenant, and there's nothing wrong with that. So we want to make sure that they have their rights distinguished, set from each other. Uh, yeah, so I just wanted to mention these scenarios. There's a whole world of leasing and contracting that gets it's very particular, very nuanced. Uh, and I think that I'll stop sharing my screen and be happy to answer any questions or just engage in general discussion. Hope you enjoyed this. All the materials will be shared with you, and look forward to talking and staying in touch.